Good evening, and welcome to the September 19th, 2022 meeting of the Lake Oswego Development Review Commission. Kat, would you please call the roll of commissioners present?
Arthur,
Here.
Shear,
Here.
Poinsett,
Here.
Lyons,
Here.
Dews,
Here.
and Dwight Sangri and Kirk Smith are excused this evening.
Thank you. We have a quorum. And our first item of business is a review and discussion of the minutes of the September 7th, 2022 meeting of the DRC. We've all had a chance to look at those draft minutes in advance. Does anyone have an addition or change they would like to suggest to the draft minutes? If not, is there a motion?
So moved. Second.
All in favor of approval of the draft minutes of the September 7th, 2022 meeting indicate by saying aye. Aye.
Aye.
Any opposed? Any abstaining?
I will abstain because I was absent that evening.
Very good, thank you. The minutes are approved of that September 7th, 2022 meeting. Our next item on the agenda is the review and approval of the findings relating to LU 22-0002. Now, this is a request for approval of a conditional use and development review permit to construct a major public facility, that being the 62,900 square foot recreation and swim center, including a 183 space parking lot on the Lake Oswego Golf Course site. And it included the removal of 88 trees. So this site, as you may know, is located at 17525 Stafford Road. We've all had the opportunity to receive and review the draft findings. Are there any comments, changes, or additions to the draft findings for LU 22-0002? Is there a motion to approve the draft findings?
So moved.
Is there a second?
Second.
Thank you. Let's take a vote on the pending motion to approve the draft findings. All in favor? Let's call the roll. Thank you.
Arthur,
Yes.
Shear,
Yes.
Poinsett,
Yes.
Lyons,
Mr. Boone, if I could confirm, because I was absent at the last meeting, should I? Okay,
You abstain.
confirm. Okay, abstain, please.
Dews,
Yes.
4-0.
Very good. The findings are approved. The next item on our agenda relates to a public hearing. This is on LU 22-0041, a multiple request for approval of a development review permit to construct additions on an existing dwelling in downtown Lake Oswego in the downtown redevelopment design district. A minor variance to reduce the combined total 15-foot side yard setback to 12 feet for the proposed second story and east additions. Also requesting a design variance to reduce the north side yard setback to 2.9 feet and the south side yard setback to 3.7 feet for a proposed west addition. Also including a request for a design variance to reduce the rear yard setback from 20 feet to 4.5 feet, with yet another design variance request to increase the maximum lot coverage from 35% to 47%, and then a design variance to increase the maximum long wall plane on a narrow lot from 60 feet to 72.21 feet. This site is located at 520 5th Street. Our staff coordinator is Senior Planner Evan Franstad. Acting City Attorney Boone, would you like to lead us into opening the meeting?
Certainly, Mr. Chair. The hearing process is as follows. This is a land use request to be considered based upon the applicable Criterion standards. The staff report lists the Criterion that staff identified as applicable to the request. It's available online and from the Planning Department. Testimony and evidence must be directed towards the applicable criteria. We ask that you specifically identify to the Commission the criteria standards you're addressing so the Commission may consider your testimony in relation to those criteria or standards. If you do not identify the criteria standards that you're addressing, the commission is not obliged to guess which standards you're testifying about and may not consider your testimony in its decision. Failure to raise an issue accompanied by statements or evidence sufficient to afford the commission and the parties an opportunity to respond to the issue precludes raising the issue to the City Council and the Oregon Land Use Board of Appeals based on that issue. The failure of the applicant to raise any constitutional or other issues relating to any additional proposed conditions of approval with specificity to allow the commission to respond to the issue precludes an action for damages in circuit court. The public hearing process will be as follows. First, a presentation by staff, then testimony by the applicant, up to 20 minutes, then testimony by parties in support of the application, followed by testimony by parties opposed to the application, and finally, testimony by those neither for nor against the application. Individuals will be allowed up to 5 minutes, and any person in attendance may cede his or her time for testimony to another person except to the applicant. But in no case shall any person's testimony be increased to greater than 10 minutes. Recognized neighborhood associations, homeowner associations, government or government agencies, or other incorporated public interest organizations will be allowed up to 10 minutes. Following that will be the applicant's rebuttal up to 5 minutes, and then commission deliberation, and any statement to the applicant by the commission of any proposed conditions of approval different than contained in the staff report and the applicant's response to those conditions of approvals. The time limits do not include time spent responding to questions from the commission. Testimony by attorneys, representatives, and witnesses on behalf of which are part of the presentation by a person shall be counted within that person's time limit. It is assumed that persons are testifying on their own behalf unless they expressly identify the recognized neighborhood association, homeowner association, government or government agency, or other incorporated public interest organization they are representing. As stated in the public notice, the deadline for submission of any written materials was noon today, so no written materials may be submitted to the commission tonight. Any person may request an opportunity to present additional evidence by requesting a continuation of the public hearing. Now, a potential conflict of interest declared on behalf of each of the DRC members to the extent of their business or employment, which each will identify. Unless declared otherwise, the respective DRC member does not have a known present or anticipated future business relationship with the project or the applicant. It is possible that a future business relationship could arise in the initiation, design, construction, or maintenance of the project through either the employment or business of the DRC member personally or through a relative as defined in ORS 244-020. At this point, I would ask the commission members to please declare if you've had any ex parte contacts, including a site visit, if you have any bias on the application, if any financial conflicts of interest to declare, and please state your business or employment. Commissioner Dews. You need to turn your mic on.
There you go. I am John Dews. I am an architect. I have not visited the site, and I have not had any ex parte contacts. I have no bias or financial conflicts of interest in regards to this project.
Mr. Shearer?
My name is Jeff Shearer. I'm a retired contractor. I did do a drive-by tonight, both on 5th Street and on the alley between, behind the property. I have no financial conflicts of interest. I have no bias, and I've had no ex parte contact.
Thank you. Good evening. I'm Randy Arthur. I'm a civil litigation attorney with the Portland office of the Bullivan Bailey Law Firm. I have no financial interest in this application and no disqualifying conflict of interest, and I have not done a site visit.
My name is Bruce Poinsett. I'm a construction safety consultant. I have not visited the site. I've had no contacts. I have no biases. I have no financial conflict.
My name is Tim Lyons. I'm an attorney with the Portland firm of McDowell, Rackner, Gibson. I have not visited the site or had any other ex parte contacts. I do not have any bias or financial conflict of interest with this project.
Thank you. Is there any challenge to any commissioner's right to consider the application? Seeing none, Senior Planner Evan Franstead with the staff report.
Thank you, Mr. Boone, and members of the commission. Before I give my presentation and summary of the staff report, additional written testimony was submitted and received since the publication of the staff report on September 9th that need to be entered into the record. Those exhibits are G200, G201, and G202. All three of those exhibits are in opposition to the proposal as were discussed in my memo dated today to the commission. The site is unique in that it's developed with a single-family dwelling and is located in the R2 zone, which is a residential high-density zone. and is also located in the Downtown Redevelopment Design District, or the DRD. Properties to the north, south, and east are zoned R2 and primarily developed with attached dwellings, either with zero lot line dwellings or duplexes. The only other single-family dwelling on this block on the west side of Fifth Street is at 566 Fifth Street. Properties to the west are located in the R6 zone, developed with single-family and duplex dwellings. The existing condition survey here shows the site is approximately 3,660 square feet with a 30-foot lot width. The existing house is 884 square feet with 2 stories. The existing accessory structure located in the rear setback will be removed, as well as existing driveway to Fifth Street. This plan shows the existing south building elevation. The existing dwelling was built in 1938 and is small stature with a height of 18.7 feet. This is the existing east and west building elevations. Just get an idea with the front and back. Here's the site plan. The proposal includes constructing 3 additions. So there's 3 parts to it. So you have the front addition to the east. Okay. So this is the front addition. Then you have the rear addition to the west for the garage and mudroom. And then there's a second-story addition where the existing dwelling is over the existing dwelling. So 3 different parts. The site plan shows the new landscape areas, street trees, and brick entry pathway. The plan also shows the setbacks, which the front setback is at 25.58 feet. The requested variance to the side yard setbacks from the east for the east addition with a combined setback of 12 feet. The requested design variance to the side yard setback for the west addition at 2.9 feet from the north lot line and 3.7 feet from the south lot line, and the requested rear yard setback of 3.5 feet from the alley. And the requested lot coverage is 47% of the lot. So here's the first floor plan. Proposal includes removing approximately 40% of the existing walls. The existing walls are shown in white. The darker areas are the new walls. This is in order to construct the proposed additions. The east addition to the front includes a covered entry porch and covered patios on the side. The west addition to the rear includes attached garage and mudroom. Second floor shows the second floor addition that includes a master bedroom and bath. This is the proposed south elevation. The proposed building height is 25.58 feet. It gives you this sense of the scale and design of the structure as viewed from the south. Here's the front rendering as viewed from Fifth Street. Proposed building materials include cement board shiplap siding, fiberglass framed windows with clear glazing, cedar tongue and roof soffits at the front entry covered outdoor area, composite decking and metal guardrails in the front porch, and metal roof with skylights. And here's the rear rendering as viewed from the alley with the proposed garage. So the first part of the applicant's request involves the DRD standards. As I mentioned earlier, the property is located in the Downtown Redevelopment Design District. The proposal triggers the DRD standards because additions change the appearance of more than 50% of the building elevations, and as such are considered a substantial remodel. The existing building is non-conforming to the architectural styles permitted in Lake Oswego styles, which, because it's not arts and crafts, English Tudor, or Oregon rustic styles. Staff finds the proposed additions do not affect the non-conforming style of the dwelling, and therefore the proposal does not increase the degree of non-conformity, nor create any new non-conformity. Design standards require buildings shall use masonry as predominant building material for the walls of the ground floor. The masonry includes fabricated bricks, blocks, stucco, and glass. The plans show the proposed cladding is cement board shiplap siding and glass, which does not include masonry as a predominant building material on the ground floor. Recommended condition of approval A1C requires applicants to submit a revised building elevation plans that show the ground floor will have masonry as the predominant material. The DRD standards require roofs to use slate, tile, shakes, or wood shingles, or synthetic materials that resemble wood shingles in some sort. The applicant is proposing clip-lock metal panels on the entire roof. Metal roofs are only allowed for small roof sections, small portions. So recommended condition of approval A1B requires applicants to submit revised plans to utilize one of the materials required in the DRD standard. Overall, staff finds the proposal complies with applicable DRD standards with the recommended conditions of approval A1 through A4. On to the next part, the minor variance. Applicant is requesting minor variance to reduce the combined total 15-foot side yard setback to 12 feet for proposed second story and east additions. For the first criterion, staff finds the proposed addition will not be detrimental to public health or safety, as additions do not impede vision clearance areas for vehicles entering and exit the site, and the fire marshal has determined that the side yard setbacks will not violate any fire regulations. Criterion 2 requires that granting the variance will not be materially injurious to properties improvements within 300 feet of the property. There are approximately 63 properties within 300 feet of the site boundaries. The adjacent properties to east and west will not be affected any more than they currently exist. The properties most likely to be affected by the minor variance request are the abutting properties to the north and south. The proposed additions will be approximately 11 feet from the dwelling on the abutting lot to the north at 540 Fifth Street, and 6.8 feet from the dwelling to the south at 518 Fifth Street, which is located on the lot line. The applicants note the proposed additions are in excess of the 5-foot minimum requirement, while also meeting the side yard setback plane, just shown on the front elevation there. The setback plane goes up 12 feet and 6 by 12 in towards the lot to keep the massing towards the center lot. So they meet the minimum 5-foot required setback and the side yard setback planes. The proposed overall height is 25.58 feet, which is well below the maximum height of 28 to 32 feet in the R2 zone. Staff finds the construction additions on the existing single-family dwelling has minimal potential negative impacts to the abutting or nearby single-family dwellings. Therefore, the proposed variance will not be materially injurious to the neighborhood or the properties. Criterion 3 requires that granting the variance will have little or no negative impact on the streetscape. Staff finds approving the minor variance for a combined 12-foot combined setback will have no negative impact on the streetscape because the front yard setback is met in a small scale of proposed dwellings and proposed street trees. Criterion 4 requires the proposed development will not adversely affect existing physical or natural systems such as traffic, drainage, Oswego Lake, hillsides designated sensitive lands, historic resources or parks, and the potential for abutting properties to use solar energy devices any more than would occur if the development were located as specified in the requirements of the zone. There are no designated sensitive lands on the site. The site is not on Oswego Lake and does not contain historic resources. There are no negative impacts to the streetscape. The proposed driveway located on the alley meets the site distance standards, and traffic will not be affected by the proposed development because existing use remains a single-family dwelling. Condition A5 requires submission of a final drainage plan, final drainage report to comply with the stormwater management standards. The property is not mapped on any hillside protection areas, nor located near any parks or open space tracks. The proposed addition will not affect any abutting properties from the use of solar devices and will not cast shade affecting the abutting properties. Staff finds the criteria for a minor variance are met. And on to the design variance. So the applicant is requesting approval of design variance to reduce the north side yard setback to 2.9 feet, south side setback to 7.7 feet for proposed west addition. Design variance to reduce the rear yard setback from 20 feet to 4.5 feet. Design variance to increase maximum lawn coverage from 35% to 47%. And finally, design variance to increase maximum long wall plane on a narrow lot from 60 feet to 72.21 feet. The applicant's narrative discusses the compliance with the setback is not practical to the location of the existing detached non-conforming dwelling in a narrow lot width of 30 feet. The code defines practical as capable of being done after considering and balancing cost, existing technology, and logistics in light of overall project purposes. The existing dwelling was built in 1938 and is non-conforming to the side and rear yard setbacks. The proposal extends existing non-conforming walls to the east in order to construct the garage and mudroom additions for the west side addition. The narrative states that in an effort to keep portions of the existing dwelling, building a garage to meet the required setbacks is not feasible, as will result in demolishing most, if not all, of the structure. In order to meet the required side yard setbacks for a detached dwelling, a minimum of 5 feet on one side and a combined 15 feet on both sides is required in R2 zone. Because the lot is only 30 feet in width, this results in a building width of 15 feet. Compared to an attached dwelling, which are required to only have a 7-foot side yard on one side and a 0 setback on the other side, resulting in a 23-foot wide dwelling. Because the applicants are proposing to retain the existing non-conforming detached dwelling in a high-density zone, in the R2 zone, the width of the allowed footprint is significantly less than for attached dwellings. Also, adding a garage with access to the alley is consistent with the placement of garages in the neighborhood. Let me go back to this site plan here. Yeah, adding garage to access to the alley is consistent with placement of garages in the neighborhood and generally desired in the neighborhood. In fact, the R6 zone to the west, new garages are required to be accessed from the alley. An alternative front-loading garage would have problems meeting the garage appearance and location standards, which are applicable to detached dwellings in R2 zone, and require the width of the garage to be no more than 75% of the width of the dwelling, addition of living space above the garage, and the garage to be set back further from the street than the dwelling. Staff concurs with applicants that compliance with the rear yard setback and side yard setbacks is not practical, and retention of some detached dwellings in the R2 zone is desirable for a neighborhood mix of housing types as part of the purposes, goals, and objectives of the base district. For lot coverage, the long, narrow lot configuration forces a longer building footprint that necessitates more lot coverage when combined with the required setbacks and setback planes. The requested variance exceeds the maximum lot coverage by 388 square feet in order to achieve a total floor area of 1,945 square feet. The maximum allowed floor area based on the lot size for this lot is 4,392 square feet. The proposed floor area is less than 50% the allowed maximum floor area for this lot in R2 zone. Constructing code-compliant additions is not practical due to the significant reduced building area that would result and would not meet the overall project purposes of providing a dwelling with a floor area that is comparable to dwelling sizes intended for the R2 zone. For the requested variance to increase the maximum long wall plate standards on a narrow lot from 60 feet to 72.21 feet, the applicant's narrative states that complying with the standard is not practical because the lot is only 30 feet wide and the existing roof pitch is 8 to 12. The narrative states that 42.75 feet of the existing structure exceeding the 18-foot height threshold for the standard is limited to a single-story volume with a peak of sloped roof, centrally located in a lot no taller than 19.5 feet. Staff concurs with applicants that compliance with the long wall plane standards is not practical because the narrow width of the lot and the design of the existing dwelling with steeply pitched roof causes single-story height to be above 18 feet. This standard is met. In considering and balancing costs, existing technology, and logistics, there are no feasible options to construct compliant additions in regards to the side and rear yard setbacks, maximum lot coverage, and maximum long wall plane standards. The second part of the design variance criteria is that the proposed variance will result in a project that is exceptional in quality of detailing, appearance, and materials, or creates positive, unique relationships to other nearby structures, views, and open space, or if in the DRD, as in the case here, the variance is necessary to create a complementary relationship with a viable existing structure on an abutting lot that is not designed in Lake Oswego style. The applicant's narrative states that the proposal results in a project that is exceptional in quality of detailing, appearance, and materials, as well as an improved view of Fifth Street and the alley. The proposed project includes high-quality materials with cement board, shiplap siding, fiberglass frame windows with clear glazing, cedar tongue groove soffits at the front entryway, and durable composite decking. Design includes multiple roof pitches, asymmetrical composition, roof, windows, and porch projections, horizontal siding that improves the perceived building form and breaks up the massing. The proposed front door orientation towards the street and the garage orientation towards the alley creates a unique relationship with nearby structures with similar orientation. Overall, staff find the design variance criteria are met for all requested variances.
Thank you, Planner Franstad. Any other comments at this point? Commissioners, are there questions of staff relating to the application? Senior Planner Franstad, I noticed that in opening your remarks, you identified that this project is considered a substantial remodel under the applicable definition. Is that a newly adopted definition of remodeling that the City Council addressed earlier this year, or is that?
That's a different standard. So this is just for the DRD.
Oh, I see.
When it's more than 50%. Yeah, for the demolition.
Oh, well, that's
definition,
correct.
That's a different definition, different code section.
And this code section doesn't address expansion of floor area, the one that applies to this application.
Expansion of floor area? Well, it's more 50% of the outside of the dwelling.
Right, and it doesn't address anything about expansion of floor area of the interior of the unit. I think the answer is it does not, but I just wanted to clarify that.
It does, to the extent that it's mainly for commercial uses. So if it's a restaurant building expansion, but obviously that doesn't apply here. So it's really just the exterior remodeling that changes more than 50% of the exterior appearance of the structure.
I see. Any other questions? Jeff?
I'm having a hard time with the expansion of the lot coverage. Could you run your analysis past me again?
I'm gonna go to site plan. I think that's the easiest way to probably understand it. Okay, so let me go back to my notes here. There's so many different details to this application. So they are requesting, so maximum lot coverage based on building height is 35%. They're asking for 47. This is the reason why the difference between 35 and 47% is 388 square feet, relatively small amount. With the narrow lot, the way it's configured, in order to make a usable area of the property, to meet the side yard setbacks and setback plane, which forces the building mass in towards the center of the lot, you have to spread out the building footprint. And anything above 30 inches in height counts towards lot coverage. So in order to make it a usable site, it expands the footprint of the house, increasing the lot coverage. In this case, 388 square feet more than permitted in the code.
So by increasing the size of the house, that would it have been better to have a smaller house with a lower roof?
Well, that was part of the issue with this is they're keeping the existing house, which has the steeply pitched roof, and they're trying to match that. So that creating a lower roof is problematic in this case. Unless they remove the whole roof and start it over with a flat roof, you would be able to get more area out of it with the setback planes. But that's not part of this project. They want to keep the existing roof pitch.
In the R2 zone, for a single-family detached, it is just 35% lot coverage regardless of the height. So there are some zones that have a sliding scale, so the taller you are, the less lot coverage you get, the shorter you are, the more. That doesn't apply in this case. However, if this was a townhouse or a duplex or a triplex or any other structure, they would get 50 to 55% lot coverage. So as a single-family detached, it's 35 irregardless of the height.
Okay, so what's the analysis for increasing the lot size coverage then?
Well, I think the analysis would be that because this is an existing single-family dwelling, or they're keeping it, they're allowed a lot less lot coverage than if they had an attached dwelling, as I was showing on the site map, is a pattern of development along this block. It's a high-density zone that allows more lot coverage for higher density development.
In addition, you have a small lot size with a very narrow lot width of 30 feet. And there's a lot of other standards they have to comply with, and that's what's forcing them to spread out instead of going towards the center of the lot and having just a 15-foot wide house.
Okay, I get that, but I was trying to get the analysis and it wasn't working, and I understand, okay, what you're saying.
So taken all together, it's staff's recommendation that the variance be granted on that point.
That's correct.
Any other questions or comments of staff? And then perhaps we can hear from the applicant. If the applicant, please come forward. Welcome. Please state your name and identify yourselves. Perhaps you could pull the mic a little closer to you. There you go.
Hello.
Good evening. Thank you for being here. There.
Hi, everyone. Hello for those who came. I'm Chelsea Bacci. I'm the owner of 520 Fifth Street. I want to start off by saying that I take full responsibility for the misunderstanding as it relates to involving the neighborhood association. I am incredibly naive about the steps and what's expected of me as a homeowner in First Edition. And I had every intention to involve the neighborhood early on and throughout the process. And I thought I joined the correct meeting. It turns out I have been informed that I did not join the correct meeting and participated in a way that I can feel proud about now. So I just want to own that. My parents lived in a home 3 blocks away when I was born. So I grew up in First Edition. They were there in 1972. And it's a neighborhood that I have long dreamed of coming back and raising my own family in. I have a 2-year-old daughter now. I'm a single mom, and I plan to live in this home until my daughter goes to college, at least, at minimum, if not forever. And I love the charm of First Edition, and I fell in love with the house itself when I bought it just a few years ago. And then reality has set in now that I have a toddler, and my motivation with the remodel is to keep the essence of the home while creating a space that she and I can grow into. We've really aimed to be intentional with the design and considering my neighbors on either side, the north and south side especially, both in privacy and space. And I'm grateful to Donald for incorporating my request to keep the look and feel of the home so that it adds to the magic of the neighborhood and doesn't deter from it. Also to include a landscaped area, for example, in the front with a porch that faces the street, so the home feels more open and welcoming, which is very different than what we see today with the house set back and the fence that separates it from the street. And those are my comments for now. Thanks.
Thank you. Mr. Schmidt?
Thank you. Hi, I'm Donna Schmidt, principal of Centerfield Studio. We're the architectural team that's been tasked on a very difficult site and in a beautiful home, but I think we had our hands full to try to figure out how to balance a lot of the things that are both for a growing family, single family house. We are excited that in an increased density, as architects, we're always working to provide more density, but this is almost a counter in that where you have this beautiful single family house and otherwise something that really wants density, as evidenced by some of the houses or developments already taking place on 5th north of B. Just for example, the house or the properties immediately south that have 0 lot lines, that are multiple stories that fill up a large percentage of the existing site. This one, in essence, although we are stretching lot coverage without a doubt, that is one of the big pieces that we're asking arguably the most for, we are working very hard to meet every other criteria, and in fact, in most cases, far exceeding or doing better than the minimums and or the maximums being asked for. So the proposed design is inspired by the existing single-family house. We've talked about that a little bit. Many of the features are in keeping. I thought the staff report with the yellow style, I should say, I thought the staff report did a very good job talking about, obviously, some of the goals and inspiration behind what we were trying to accomplish from the design. Let's see if this guy's working. Uh-oh, I get the wrong ticker. I might steal Evan's, yeah. So I'll kind of zoom ahead. I've taken kind of a number of existing photographs as well for those that weren't able to get to the site. we were inspired by some of these features, the gabled roof, the asymmetrical compositions. We loved the bungalow nature of the site, so obviously just on 5th north of B alone, these are immediate precedent houses. Some are multifamily, many are single family, and there's a certain material palette and just kind of overall feel that we were excited about in trying to maintain. The project proposes adding a step-back second-story addition over the existing structure. We talked about that, as well as a single-story addition to the east. I thought the staff report did a great job of trying to break apart kind of the challenges and really how we tackled the design as well. Where in essence we're adding the second-story addition over the existing volume, trying to maintain the character in some of the early design. Come on, baby. There it went. Sorry. For the single-story addition towards the east, that's kind of our larger family, living area. It's where the kind of entry of the home exists. So we wanted a kind of large vaulted, kind of much more inviting space, and then you transition more towards the more private spaces towards the rear of the house. The west addition is situated along the rear alley. It's got an enclosed garage parking located along the alley, which is part of a prevailing neighborhood pattern with setbacks ranging from 4 to 5 feet and is represented in the provided site photos. So one thing we did want to talk about for sure, if we look at the alley, you can see multiple examples. The upper right image from alley looking south, it says, that is the property. Our property to the left is, you can just see the peak of our little gable roof beyond, and so you've got a property right there already. To the opposite side, you have the fence. And so you're seeing it's a prevailing condition. It was established in the staff report as well. I think what we're proposing to do is continuing to add to a character back there that is kind of a walkable alley and lots of engagement, but setbacks have obviously been reduced relatively significantly. Let's see. And the other big effort here, as outlined in the staff report, was the effort to take the existing parking and all of that and locate it to the rear by taking it off. The challenge for us as it relates to setbacks, both in rear yard and side yard, is relative to that existing structure in order to get an 18-foot parking stall, plus the accounting. We're only proposing a single-story garage. We're not proposing a double-story or two-stall parking garage, but it results in encroaching further towards that rear yard setback in particular. So while we understand the product is proposing a significant increase in lot coverage, the design works to offset any concerns regarding coverage through a combination of stepped massing, quality materials, building design, and increased landscape areas. A large percent of this was in specific, and Evan outlined the idea of the 388 square feet. Well, the garage alone represents 292 square feet of covered area. So to put that in perspective, that's a large ask in what that lot coverage request is for, is housing the garage. We realize, and while we realize our choice was to, or my client's choice was to develop a single family house, it's worth noting, and it was pointed out by staff, that the zoning in this particular area allows up to 55%. We're at 47, we understand that. Again, part of that is related to covered outdoor areas, part of that is to enclosing the garage. And lastly, in relation to that, landscape, the required area is 15%. We're providing 30% landscaping. We're providing multiple street trees. So in one sense, it's just kind of this odd duality. Lot coverage is the kind of shiny object that says, wow, that seems excessive. But in reality, you go and look at side yard setback plane, front yard setback plane, you look at landscape coverage, you look at kind of all these things that typically describe building mass, relation to side yard setbacks and all these other elements, and the project somehow is complying with the exception of rear yard setback, and we understand that.
Thank you for those comments. Commissioners, are there any questions for Ms. Bochi or Mr. Schmidt? Well, thank you very much, and I especially appreciated the front porch, which I think is welcoming, as Ms. Bochi was saying, and I think is consistent with the neighborhood plan in that area. So thank you very much. Is there anyone here tonight who wishes to speak as a witness in favor of the application? In favor? We have some who would like to speak. Sonia Lindsay, who I believe is opposed. Is Sonia Lindsay? Miss Lindsay passes. Grace Dezawa, I'm sorry, I may be mispronouncing. Grace.
Rawi, is that what you're trying to say?
Well, I'm just reading this handwritten note.
No, Iraqi is not, it's not easy. It's an Iraqi last name, Jezrawi.
Are you Grace?
I am Dr. Grace Jezrawi.
Please come sit down with us at the witness table, please.
Thank you.
And you're speaking in opposition to the
I
application?
am speaking in opposition. As you can see, I have two amazing little miracles right now, and we're actually expecting another one on the way. So we will be it will be 3 kids and my husband, Dr. Saad Jezrawi, and myself, and we've lived in the yellow house. My husband has owned this for I think at least 12 years now. I've been here 5 years since we got married. But the way it's built, the way our house was built is literally on the property lines. So there is no space between the property lines and our house. Mind you, any separation between her house and the property line. So it's literally our house on the property line. That's just how it's built. So both my husband and myself are both physicians, and we just love our neighborhood, and that's why we're staying, honestly. With 3 kids, it's a little tight. We don't have, what is it, hon? How much square feet? 1,400. So we're in 1,400 square feet, but we're 3 kids, and we love our neighborhood. We've built it into a community. And we really want to stay. And we have a little patio in between our main house and the garage. And we actually looked to do some work to increase living space in the garage. So we've gone over the rules recently. And we saw these rules of at least 5 feet with a minimum of 15 feet on the side of each property, and respected it. You know, we didn't make a whole other living space on our patio. We didn't increase the living space. We didn't, and we're not doing that with the garage either. So it's a beautiful place to live. Could we go into a larger house? Yes, but we love the people around us, and we love the kind of feel of the community, and we've respected in keeping our house that way. And so that's that. I just feel like it would be a little. I feel like our privacy would be a little bit violated, honestly, because the second part of their new house is going to look right on our patio. And we learned the rules and followed them. We didn't ask for any variations, and we're just asking other people to do the same. Okay.
So just for my understanding, looking at this illustration that's on the screen, the yellow garage, 520 is right next to your
Correct.
Garage on that side of the street?
Correct.
Any questions for this witness, Grace?
518.
Thank you very much.
Sure, thank you. Sorry for the extra noise.
Mommy, I want to do.
And Dr. Sayad, are you wanting to speak tonight?
Yeah.
Please come forward.
Thank you. Sorry, I'm so
Please state your name and.
Yeah,
Wonderful. My name is Saad Jazrawi. I'm the neighbor in 518 Fifth Street, and I'm gonna just kind of mumble, hopefully correctly on things. I just want to, I mean, first I'm opposed to the design. I think it's too big, too close, and no, I mean, it just worries me the direction we're changing our. I just want to correct maybe Evan if I misunderstood him. He said there is the house near, we live in a single-family home ourselves. So you said the homes on both sides are not single-family homes. So that's incorrect. And actually, a bunch of the homes that are in that street are actually single-family homes. And I'm happy to connect you to the owners of them if you need it. So that's an inaccurate statement when you describe something about the variances and minor and things like that. The other thing I want to highlight in this, again, I moved in this neighborhood, liked it. I live close to my work. I work at the hospital, at the university. I take the bus. I am not happy with the current design because it is too close. It is very, I don't know if it's, I mean, we live in a 1,400 square foot with 2 kids and we're making it work. And yes, our home built before the current code. That's not my fault, you know, but it's also this codes were there when the house was built. So why buy a house and change the rules or ask for the rules to be bent for you instead of actually complying with the rules? This is, I know when the house was bought, I was there and I saw it was an attractive area. People just put an offer, put it over. They went over, I think 50,000, it doesn't matter, good for them. But I see that happening, and we're priced out. I am a physician, I'm priced out from the Oswego. But if it happens, I may leave if this is what it takes. We've built a community, especially with my wife. I'm not a community builder, my wife is, and we built a community. I have these 3 pictures. I want to share it with the committee. They can look at it. There's like 5, 10, 15 kids playing around in the alley. How are you going to build this?
Have those been already received in the record?
I didn't know there was a way I can receive it. You don't need to receive it.
You would have to ask for continuance in order for the materials to be submitted in the record.
That's fine. I am not a lawyer. I mean, I'm a physician. I take care of people. When somebody asks me of something, I say the truth. So that's going to be my statement. It doesn't need to be applied. It's fine. Okay. There's 10 kids playing, 15 kids another over the past 3 years actually since my daughter.
So your photos show children playing in the alley?
On different times. Okay. COVID saved us, actually. I mean, I guess the street saved us during COVID because, honestly, my daughter haven't met kids. The only kids she meets is the neighbors around us. We play in this neighborhood. Yes, there's a couple of homes that were built, I forgot, 15 to 20, 25 years when the code was allowed, maybe 25 years. I can't change those codes. But we know no single code could be changed now because these are the rules. So we accepted it, we like it. I was in communication with the homeowners, the neighborhood association, and somebody highlighted that the shack you see in the picture, apparently, it was built without permission, supposedly, and I don't know. I let somebody to look at that. Somebody has to look at it. I mean, yes, there is a space, but you put a garage that extends all the way to 3.5 to 4 feet away from where would those kids, I mean, basically you have to think about the car coming in. I mean, that basically has to cut on my house to get into the garage. I have 2 cars. I don't know. I mean, these are things, it challenges things. I actually reminded by Sonia, who's the other neighbor on the other side, and we were both displeased with that. There was a tree in front of the house. One day we came up and it disappeared. I was like, I have no idea how it disappeared. Like, oh, interesting. Yeah. So again, it happened after the sales of the house. I don't remember the tree, but I know it was disappeared because the house all of a sudden had a better view. Again, things like that happens. I would love for Chelsea to join us, but not to join us on our expense. Half of our neighborhood is changing to rentals. If that's what the committee feels eventually, that is fine. I talked to Evan, and he says they have the rights, and it's like, you're not getting it. You want people invested in the property. I am here 12 years, and I hope to stay longer. I live in New York City. I know it's a density. You live in density, but you don't push your way. You don't park a truck in a compact car parking. This is not how it works. You know, and they say, well, you know, I need to build a truck. I need a truck parking. You know, you respect the expectations. I don't know, I mean, just give me a second to check things, you know. I know the property has challenges, I know that. I saw the property when it was being, you know, the owner before that, Charlie's a friend of mine. But, you know, being challenging design doesn't mean it comes on my expense, I mean, on my family's expense. I mean, I have a child who's gonna have to walk outside with a, you know, and I'm gonna have to keep checking on the property. For somebody who didn't care, in a way, build a shack and cut a tree and not gonna care about, you know, in the longevity of the neighborhood. These are concerns that I have. 50% of the property, why do you wanna go 47%? I mean, you know, go up. I mean, it concerns me. And again, I'm sorry if I'm going back and forth because
I think your time is about up if you wanted to complete with a final sentence, and then we'll ask you to stay for any questions.
I just want to say something. If the design has a non-conforming thing, why extend the non-conformity to more non-conformity? I mean, it's like, well, you know what, you're growing something in your hand, well, let it grow. It's like, it doesn't work that way. I mean, when you're going opposite direction.
Thank you.
Yeah,
Your
sorry.
time is up. Just a minute. Are there any questions for the witness? I just wanted to ask you, so looking at the image that's on the screen, the upper left hand, as I'm looking at it, the yellow garage, what do you estimate to be the distance between the yellow garage and the white garage?
It is, I'm going to say 3 feet.
Living there, what do you estimate it to be?
I don't know, 3 feet.
And on the other side of the yellow garage, and I think there's a fence there, what is that clearance, if
It's
you
probably
recall?
about 4 feet, something like that.
And the distance between your garage door to the alley, do you have an estimate of what that is?
20 feet.
I see.
Yeah. It is now, just to say, I'm sorry, it is now, I think, 8 or 10 feet. They want to extend it to 3.5 or whatever, 4 feet.
I was asking about the distance from the garage to the alley.
My garage, yes.
Yeah.
Yeah, but, okay, sorry.
Okay, any questions?
Yeah, I just want to also clarify, looking at the site plan, your house does come right to the property line?
That's the way it was built before, I mean, that's the code at the time, sorry. Thank you, yeah. That's the code when it was built. Yeah.
Yeah. I just wanted to clarify, so it is on the property line?
Yeah.
Thank you. Any other questions? Thank you very much for being here this evening.
Thank you, appreciate it.
Any other witnesses wishing to testify in opposition? Marilyn Rudin? Are you Marilyn? Please come forward. I understand you're wishing to comment, but you're neither for nor against. Please join us.
I'm Dr. Marilyn Rudin, and apparently
Sorry, I don't have your degree titles.
could you put up the map of the first edition? This one? Oh, can I do it?
Just click back.
Okay. First of all, congratulations, that is a very difficult lot. And it's kind of pretty, too. So I'm Marilyn Rudin. I currently live in Westlake. I just built a house in Westlake. This is my third house that I've built in Lake Oswego over the last 60 years, good Lord. And I built on 6th Street, 516 6th Street. Do you see it there? It's a 50-foot wide, and it's a very skinny house, and it has almost no, it's tucked up against the lot line on the north side. And then looking at 520, that is an almost impossible lot, in my view, to build on. I still own 535, 529, right in back of you, and that is a duplex, and it is a rental, and I'm here to make sure that that's not impinged upon, and I don't think it will be. But my question is, there is a breezeway on this design, and does the garage have to be detached from the house? Is the breezeway a requirement?
Well, these are questions you could ask of our planning department. We're really here to listen to you.
Right, because if it is requirement, which was in my house on 516 when I built it, if you remove that requirement, perhaps the building could be shorter and be pulled together
Do you mean if it were attached?
if it were attached. If you made that design element change and gave that variance, would that change the structure and would that change the neighbors' issues? That's my comment, if that could be done.
Thank you. Are there any questions of Dr. Rudin? Thank you for being here. We appreciate your comments. Are there other witnesses who wish to comment on the application, LU 22-0041? Sonia Lindsay, did you wish to comment in opposition? Please introduce yourself and we welcome your comments.
Thank you. I'm Sonia Lindsay. I live at 540 5th Street, so I am north of the 520. My concern is the overall size, how this is just, in my opinion, more than maximizing the lot. My biggest concern are the setbacks to the north from the 520 proposal addition, remodel, whatever you want to call it, to my lot line. It seems very narrow. I don't know if I'm reading the plans. I received a survey report just today. I'm concerned, can you even get a yard debris can through there? If a fireman had to get through there, could he get through? I don't know. I guess that's my question, is I'm not quite sure what the setback is and how that relates to me, but I just think overall the footprint, my understanding initially, I thought Chelsea was going to, excuse me, add on to the existing bedroom downstairs and then enlarge the upstairs to put a primary bath in there. I didn't realize it was going to go so far to the east, but I guess I'm just concerned about the height going up. I'll lose more natural light coming in if it gets taller and comes closer, and that's just basically my concern because these are old. I think my home was built in '54. I've lived there for 38 years. It's been my primary residence, raised my son there, love the neighborhood. I'm getting squished out, is how I feel. So my concern is the direct setbacks and how they would be close or far away from me. They seem to be encroaching on my dwelling as well. So that's my comment. Thank you.
Thank you. Any questions for Ms. Lindsay? We appreciate your testimony. Thank you. Then the applicant, if there's no other testimony from the public, we could invite Ms. Bocci and Mr. Schmidt back up as the applicant to give any rebuttal. If you have any.
It's on my presentation.
Yeah, so just a few points, just to the last comment. So the second story addition has intentionally been stepped back. We do meet the solar balance point standard by the city, but that standard, we are asking for a minor variance relative to side yard setbacks for the second story addition over the existing dwelling. The addition to the east, there was a comment about not necessarily being aware of the extent of that. Again, we are, the mass has been stepped back. We're in both cases stepped back beyond the 5-foot minimum setback requirement. In both of the minor variance setback requirements, it's the aggregate 15 feet that we're falling short. So as it relates to the north and or the south, given the narrow lot line, we kind of hedged our bet and split the difference. So the middle of the volume is in the middle of the lot. So if we shift it to the left, the site to the south gets more penalized and so forth. The breezeway in the middle was another comment. That's not actually a breezeway. That's actually just kind of a reference point in kind of an architectural gesture of establishing old versus new. So it's more of kind of a transition point between the primary living areas and the more kind of private sleeping quarters of the bedrooms. Squishing that and shifting that would just result essentially in what we were talking about earlier, and essentially requiring demolition of the existing structure, and/or we would turn the existing structure into a garage, which really isn't our design intent. We want to inhabit the existing structure. Relative to the lot to the south, the side yard setbacks, I think that's illustrating our whole point. We actually could begin to pursue a much more dense zone. You know, we have rights to pursue a higher density zone, a higher massing, go to a 55% lot coverage. This proposal isn't trying to do that. So, you know, we understand it is stretching a lot. There are a lot, you know, there's multiple design variances, there's multiple minor variances that we are requesting. It is a very challenging lot. We've tried to do our best to compress everything towards the middle of the site as much as possible. That was a very strategic, trying to be the best in all things. Relative to the alley, again, multiple precedents along the rear alley. I'm not sure I fully understand the comment relative to the kids playing back there. To us, that's even better. We think we're beautifying the alley. We think we're adding character. We think we're showing landscaping. We're adding a window to the rear. You know, the existing condition is just a parking lot. You know, it's a kind of an empty parking space. So I don't necessarily understand how this project would inhibit that type of relationship that was discussed there.
Ms. Bocci, do you have any additional comments?
Not much. I think the only thing that I'll add is just how difficult it is for me to be hearing from both my neighbors when we were really intentional from the day. I remember the first time I met Donnie, the first thing I said to him was, whatever we do, let's keep the charm, let's keep the essence, and let's make this more a part of the neighborhood than ever. And again, I want to raise my daughter there, so I hope that she can be playing with the kids on the street.
Thank you. Commissioners, do you have any additional questions in this rebuttal period for the applicant? If that's okay. I think, if I understood it correctly, I think there was one comment about a loss of privacy in an adjacent backyard resulting from the second-story addition. My question is there any landscape screening or any screening you could do to protect the adjacent neighbor's privacy from feeling that they're being watched from the second-story addition? I don't know if there's room for that or if there's anything.
Well, one thing we could, we could limit fenestration, like windows, for example. We could add more skylights as an option. I was going to ask Evan if it's possible. Yeah, so exactly. We're showing two larger. It is possible to consider skylights as an option. You know, I think there is a discussion about whether the windows themselves, the existing house has windows on the single story that are already facing that side yard.
Yes.
I will say on the flip side of that discussion, just please keep in mind, they are a zero lot line, and we're essentially adhering to at least a minimum standard of setback. It's an interesting comment about privacy when the one has a zero and we have a setback. But at the end of the day, yeah, there are possibilities of us to consider. We could consider screening. There's a discussion about the windows, the specific location. Obviously, having south-facing windows is a preference for the design, but there are options.
Well, I understand you to be going forward with this proposal, which is certainly your right. What, if any, landscape screening could you do for privacy in that, from that second floor?
Well, landscape would be, we really could do nothing landscape related wise. Anything over 6 feet is going to be considered structure, and there's no option that way. There are options at the, you know, fenestration and things like that on the property line. But aside from, you know, yes, we could plant bamboo or some version of that, you know, as a planting component. You know, and that, you know, and if you look at the existing site, you know, even, you know, if you look at the house as it sits today, to the north, there are considerable laurel hedges that add that kind of measure of screening and privacy to begin with. Obviously, the challenge is we're already dealing with, 3 feet or a little bit less than 3 feet. And so any type of hedge is gonna have to maintain an elbow room of less than, 30 inches to really survive.
Do I understand you to mean that there's an existing hedge between 520 and the existing yellow
For a
house?
significant portion, so moving east, where the addition, our east addition, so to speak, is happening, to the north property line, we do have some laurel hedges that are running along that property line.
And that provides some privacy from the second-story view into the adjacent.
Yeah, very little, right now there is a second story. The second story has skylights and what, 1 or 2 windows? I can't recall. 2 windows. So it's not, it's the skylights. And so it is a different relationship for sure. And that's why I say it is possible we could double down with additional skylights, for example. Right now, I think we just show the 1 in the proposed new addition. The one thing I do need to balance is to make sure that we are still able to accomplish an egress window out of the bedroom at that level.
Thank you. Any other questions or comments for the applicant? Thank you for those additional remarks.
Oh, yes.
City Attorney, would you like to inquire about the record?
Thank you. Prior to closing the public hearing, any person may request an opportunity to present additional evidence. If a request is made, the public hearing would be to either continue to a date certain, not less than 7 days later, or the record will remain open for at least 7 days after the hearing to enable additional written evidence or testimony to be submitted, and the commission would establish the period for any rebuttal written evidence to be submitted. Is there a request to present additional evidence? Hearing none. Unless waived by the applicant, the commission would allow the applicant at least 7 days after the record is closed to all the parties to submit final written argument in support of the application. That information will be considered part of the record, but would not include any new evidence. So does the applicant wish to submit final written argument, which would delay the commission's deliberation and decision until next meeting? Or do you wish to proceed as based upon the evidence and argument? You may proceed with deliberation, Mr. Chair.
Okay, well, thank you very much. Are there any comments or additional questions of staff about the evidence we've heard?
I have a question of staff. One of the public commenters brought up the issue of fire, and I thought I'd seen something in your report, but with the additional lot coverage, was there any due diligence to look at a potential impact on fire access or coordination with the fire marshal, et cetera?
Yes, fire marshal submitted comments. It's exhibit F6. Did not find any access issues or anything like that. I guess it's important to note that when they come in for building permits, the new walls will have to meet fire and building code, and which will require firewalls when they're closer to, I think, 5 feet of the property line. So I talked to the building official. He said it'd be most likely a 2-hour firewalls and approved fire openings with windows and.
Any follow-up on that?
No, no, thank you.
Other questions? Comments on the application in the vein of deliberations?
Sure, just for our discussion, I mean, I think one of the things I'm struggling with a little bit here on this is the standard of practicable. It seems like, in order to build a larger house on this lot, it is not practicable to do so without granting these variances, but that also seems a bit circular in that perhaps the variances shouldn't be granted to begin with. So I guess that's just what I'm kind of toying with on this.
Does staff have any comment about the issue of practicability and the extent of variances that are reasonable and appropriate to make development practicable on this site?
Well, I went through my presentation quite a bit. I guess I could go through.
But we've
it
read
again.
your staff memo, which was
Yeah.
nicely done, and heard your comments. I didn't know if you had anything more to say in response to the question or comment.
Not unless you have a specific question. Given the small lot size, narrow lot width, existing dwelling, and the ability to keep the existing dwelling practicable, in the definition again is capable of being done after considering and balancing costs, existing technology, and logistics in light of overall project purposes. Given the definition, I don't think it's practical to meet the requested standards.
Commissioner?
Yeah, I
Hughes?
just had a comment. I just want to, reiterate, it's a very narrow lot and a very small lot. And the addition, as you pointed out before, if you look at percentages, it's up to 47% coverage now, but that's on a fairly small amount of square footage, but it gets exasperated when you look at percentages on such a small lot like that. So I don't like to look at it in terms of just that statistical data. It just skews it. I think you have to look at more what's reasonable and what really works. And I think in terms of, it's an older area also. And when these zoning rules were put into place, obviously there was a lot of nonconformance to begin with. And I think this still tends to meet with the spirit of what was trying to be accomplished in terms of the overall. So that's just my comment on it.
It's my recollection the expansion from 35 to 47% lot coverage is about fewer than 400 square feet. Any other comments or thoughts on the application? Jeff?
I was really struggling with the overall lot coverage. Having gone down there and driven by on the way here, the closest of the houses are 6 feet or less in a lot of locations on that block. So that doesn't, the setback issues doesn't bother me on either side. To me, the garage setback doesn't bother me because you drive down the alley, a lot of the houses are already that close to the alleyway anyway. It would be nice if they, if it had a few more feet back there, but everybody else has already done that. So to me, that horse is already out of the barn. The overall lot coverage, I really had a hard time with. And I appreciate your comments very much. So I probably would vote for it.
Thank you for those thoughts. And as I indicated, one of my concerns was just the privacy of the addition of the second floor overlooking the backyard of the adjacent property, as I understand it, not having been there in person myself. So if the applicant could do something with bamboo or something, I think was mentioned, to provide a little additional screening, I'm sure the neighbor would appreciate that. Is there a motion on the application? I would move to approve the application with the conditions mentioned in the staff report for LU 22-0041 as submitted and recommended by staff.
I'd second that.
Let's call the roll, please.
Arthur?
Yes.
Shear?
Yes.
Poinsett?
Yes.
Lyons?
No.
Dews?
Yes.
All right, there's a tentative decision by the commission to approve. Written findings to be brought back to the commission on Monday, October the 3rd at 7 p.m.
Thank you very much. We'll now proceed with our next item on our agenda, which is LU 22-0022, relating to the Lake Ridge Middle School complex. This is a request for a conditional use permit modification to increase the duration of use of the athletic fields by installing field lighting, artificial turf multipurpose athletic fields, and a running track. And it also includes a development review permit to construct a concession stand, dugouts, and other pedestrian improvements, again at the Lake Ridge Middle School. Also involved in this application is a request for removal of 2 trees to accommodate the improvements. As you may know, this site is located at 4700 Jean Road in Lake Oswego. And Associate Planner Ellen Davis will present the staff report. Welcome.
Good evening, Commissioners.
And before you go into that.
I'm sorry, I jumped the gun there.
Nope, no problem. We have,
Hold on to that thought, please.
I think most people have sat through it. Was everybody here for the first reading? Okay, with that, Mr. Chair, in light of trying to move things along, so people will address the criteria. The presentation will be by the applicant, 20 minutes, other party by 5 minutes. And I think we can probably get to the DRC declaration of any ex parte contacts, including a site visit and bias on the application for financial conflicts of interest, and state your business or employment.
I'm John Dews. I am an architect. I have driven by the site. I have no ex parte contacts in regards to this, nor do I have any bias or financial conflict of interest.
My name is Jeff Shearer. I'm a former contractor. I'm very aware of the site. I've had no financial, I have no financial conflicts. I have no bias. I've had no ex parte contact. I didn't make a visit there, but you know, my kids went to school there and I played sports there, and so I know it very well.
I'm Randy Arthur. I'm a civil litigation attorney with the Portland office of the Blomenhauser Bailey Law Firm. I have no financial interest other than being a taxpayer in Lake Oswego, and no disqualifying bias. I have not made a site visit. Bruce?
Yeah, I'm Bruce Poinsett. I am a construction safety consultant. Have visited the site a while back. Have no ex parte contact, no biases, no financial interest.
My name is Tim Lyons. I am an attorney with the Portland Law Office of McDowell, Rackner, Gibson, PC. I visit the site daily. My daughter goes to school there. No ex parte contacts, no bias or financial interest in this project.
Thank you. And to clarify Chair Arthur's comment, the impact of this would not have any effect upon your real property taxes. So I don't see that.
I'm certain that I do pay taxes that I think at some point support the schools and
no, this
support
approval, this
the
approval,
additions.
yes or no, will not have a financial impact on your
Thank you for
property
that
value.
clarification.
And Kath, there's nobody on Zoom. Maybe I was being a little too flippant. Okay, all right. So with that, is there any challenge to Commissioner's right to consider the application? Hearing none, then Senior Planner Ellen Davis with the report.
Good evening, Commissioners. My name is Ellen Davis, and I am an Associate Planner for the city. I would like to begin by introducing Exhibit 204, G204, into the record, which has been emailed and printed for you. This is a comment in opposition to the application. We will be discussing LU 22-0022, athletic field improvements at Lake Ridge Middle School. The site is located at 4700 Jean Road. It has access on Jean Road, which is a major collector. The middle school site is zoned public functions and is about 28 acres in size. Currently, the site is developed with the existing school building, which is located in the northwest portion of the site. It was constructed or approved in LU 1857. It's finished construction. There are also existing parking and access off of Jean Road in the north of the site. There we go. Access and parking facilities. And the area that we're going to be discussing tonight in specific is in the southeast corner. These are existing athletic facilities. The site plan, again, you can see that the area we are discussing is in the southeast of the site. The existing access, parking areas, school building are all going to remain. Focusing in a little bit more on the site plan specifically, the new facilities include a artificial turf field. Oops. There we go. So the artificial turf field is going to be in this gray in the middle. It's a multi-use field. There are a number of lights. There are existing field lights on the site. There are new lights kind of indicated with yellow, 8 new lights, again, replacing existing lighting. There's also track and field facilities up in this area and a track circling the site, in addition to a concession, restroom, and storage building right here. Some new pedestrian connection to the rest of the pedestrian circulation on site. Dugouts for the 2 baseball diamonds next to the baseball diamonds. And the existing telecommunications facilities, existing landscaping are all going to remain on the site with some augmentation for the landscaping, not the telecommunications facilities. As discussed in the staff report on pages 7 to 9, the application complies with the criteria for a conditional use permit modification. The aspects that are considered a conditional use permit modification are the artificial turf field, the replacement of the field lighting, and the addition of new track fields and track facilities. There is also the baseball dugouts and the new structure for the construction building are considered minor development. And those are a development review permit, not a conditional use permit modification. So there are 2 aspects to this request tonight. The application complies with the criteria for a conditional use permit modification because the proposal meets the use and dimensional requirements of the public function zone and the use-specific standard that educational institutions provide on-site circulation and safe ingress and egress. The site is physically capable of accommodating the athletic facility improvements because the proposal complies with all applicable city codes. Sufficient multimodal access and parking already exist on the site. Public utilities are available. Existing landscape screening along the east property line will remain, and additional screening will be added, and emergency access will be maintained as shown in Exhibit E16. Regarding the final CUP criterion, the functional characteristics of the athletic facilities can be made reasonably compatible with uses in the vicinity because the existing athletic fields have been in continuous use for many years. Although the improvements are expected to increase the number of sports that can be played in this portion of the site and increase activity during wet weather, the existing fields and existing field lighting in this location have coexisted with the surrounding residential neighborhood for many years. The proposed modifications do not substantially change the existing uses on the site. Staff finds that the conditional use permit criteria are met. The proposed minor development components, including the concession structure and dugouts, comply with the design requirements of the PF zone in addition to the dimensional standards. Here are some renderings of the proposed structures. So in the upper right, that's a concession/restroom/storage structure, and down below is an example of what the dugouts are proposed to look like. The application does include replacing of the existing field lighting. The new lights will meet the performance and special exception lighting standards and provide lower light levels at the property lines than the maximum permitted under the special exception. There's virtually no light spillover except along the east property line. It's going to be basically impossible to see from over here, but I can tell you that along the south property line, we have about 0.00 up to 0.01 foot candles. So very little, and as we get farther along the east property line, we again get to 0.00, 0.01. The highest level of lighting is down here, which still is less than the maximum allowed under that special exception. And I will note that it is not necessary to meet the photometric standards, the lighting standards in our code, but there is additional landscape screening proposed along this east property line. But those lighting levels do meet our standards regardless, even without the landscaping. And The applicants have provided some background information about improvements in field lighting. So technology, including shielding and directional light focus, will decrease glare for neighboring properties compared to the existing field lights. The photometric plans were designed and signed by a certified lighting consultant in compliance with the criteria of the special lighting exception. And a 10 p.m. shutoff curfew is required by code. So these field lights and also the lights on the concession building will be required to turn off automatically at 10 p.m. And I will also just quickly note that the field improvements do not require any additional parking. This was one of the comments that we've received. Minimum required parking for middle schools is based on the auditorium size or the number of classrooms, whichever leads to a higher number of spaces. There are no changes to the auditorium nor any new classrooms proposed as part of this application, so no additional parking is applicable. The maximum allowed parking is actually already provided on site, and no additional parking can be constructed without additional classrooms or auditoriums space to allow that expansion of additional parking. We've already maxed out parking on the site. Moving on to tree removal, 2 trees are proposed for removal to accommodate the new running track. These trees are located on the south of the site, right here. Both trees are right next to each other and directly in the footpath or the path of the new track. They are 2 Oregon white oaks, 27 inches and 33 inches diameter at breast height. They are co-dominant and in good condition. Staff finds that they are not significant trees as defined in Chapter 55 because even though they are larger than 15 inches, healthy and not invasive tree species, they are not significant to the neighborhood due to size, species, or distinctive character. There are about 15 other Oregon white oaks of similar size in the same general area in that portion of the site that are going to be protected during construction. So these 2 trees are not a unique species, as there are other Oregon white oaks in the area. They are not unique because of their size, as there are other trees of similar size nearby, and they are not located in a prominent location like a distinctive street corner. Nearby trees that are proposed to remain will maintain the neighborhood skyline and aesthetic. And then looking at screening, it's a little small in this view, but in the upper right, you can see I've noted the trees are kind of back here behind the existing telecommunications facilities. The trunks don't provide screening to the site. The foliage and the majority of the canopy is above sightlines for people on the school site and on neighboring sites. So they don't provide a significant screen for off-site. These 2 trees are not street trees, and they are not more than 50% of the stand in which they are located. So according to LOC 50-02080, trees number 36 and 37 are not significant trees, and the applicant does not need to address alternatives to their removal. However, the applicant's materials do discuss exploration of alternative site plans during the planning phase. The current proposal was selected to limit curves in the running track and to limit the construction impact on the other Oregon white oak trees to remain. Again, these trees are not significant and alternatives to their removal are not required by the tree code. I'll note that 2 native species mitigation trees are required, but the applicant is proposing to plant 25 native species mitigation trees, well over the minimum requirement. Staff finds that all applicable criteria are met and recommend approval with the conditions listed in the staff report. Any questions?
Commissioners, at this point, are there any questions of staff or about the staff report? Hearing none, I think we're ready to hear from the applicant, the Lake Oswego School District. Please come forward. Good evening.
Hello. All right. Chair Arthur, Commissioners, thank you for having us here tonight. We don't really have much more. Ms. Davis did an excellent job with her staff report. We concur with the staff report as well as conditions imposed for the project tonight. A couple of things I did want to touch on were some of the outreach that we performed early on in the development of our plans. Youth sports, our staff, students at the school, as well as our athletic directors at Lake Oswego School District, Parks Department as well, talking about needs for some of our athletic teams, our clubs, sport that happens within the school, as well as these feeder programs that go up through our high schools into our track programs, baseball, softball. This field, it is multi-purpose, which means that it can support a whole host of different programs. We're very excited to be able to provide that here in Lake Oswego, bring our programs back here where they belong. I think I'd like to open it up to questions if the commission has any questions for us.
Commissioners, John?
Yeah, looking at the plan, there's a number of specific equipment that's being put into here. Shot put rings, high jump pit, long jump. Is the idea, I take it that was all part of the scope of what was being asked for this. Correct. So there had been a comment that the track isn't regulation and can't be used for track meets, but it looks like you're planning to actually have competitions here. Is that correct?
This site will primarily be used for practice, and as kids prepare to go into track and field at the high school level, a lot of this will support those efforts. They do a lot of these activities at the junior high level, and so this will be a perfect facility that will bring them right into the high school level. That was one of the goals for our staff at the site.
Okay. Thank you.
Jeff?
One of the, and maybe you touched on it in the staff report and I didn't see it, but filtering of the microplastics from the field, is that, I didn't see where that was covered or how that was going to be dealt with.
Do you want to talk about? Yeah,
is that the sand filter?
We've worked really closely with the engineering department too on the concept for this. So there's a sand filter under the field, so all of the water and all of any product that comes off of the field has to go through that sand filter, get filtered through into a detention area, basically a big pit with lots of rock before it's sent out to a pipe to the storm system for collection. So there's quite a bit of filtering that it does before any of that product can leave the site. And it's detained, so it's only let out of the site at a certain speed.
How's that sand filter cleaned?
The sand filter doesn't get cleaned. It's just a 12 to 18 inches of sand that is just there permanently under the field.
Okay. How high are the light poles?
They vary from, I think the tallest one we have is 80 feet, and I think our lowest is 70 at this point.
And what are they now?
I think the current poles are about 65 feet, so these are slightly taller. That was part of the reason we put that exhibit in there to show some of the photometrics with light glare. It doesn't necessarily help the neighboring to have it shorter. I know it always seems like a shorter pole would help, but it actually makes the light glare quite considerably worse. So that exhibit kind of shows why we were trying to go up and kind of keep the lights pointed down instead of out.
All right, that's it. Thank you.
Thank you, Jeff. Other questions? Tim, did you have any questions? Bruce? Nope. I have no questions. Thank you. Did you have any other comments you wanted to conclude with?
No, the only thing to touch, when we went through a large design process to come up with this to try to meet all the stakeholder requests and, provide enough activities for all the different youth activities that use this existing facility. So we did make a concession to do this track that is not regulation in order to fit all the fields inside and continue to use the field somewhat as it is. We did lose one field in overall in doing this, but we feel like the efficiency and some of the gain with the track facilities are going to serve the wider array of the community needs. And the jogging track is actually kind of a nice element that we're hoping that the community also embraces as well as a kind of a unique element for the site that can be used outside of school hours as well.
Well, I do appreciate your engagement with stakeholders and your willingness to consider the trees. I think our community is concerned about vegetation and landscaping and tree preservation as much as possible, and appreciate the programs the school district offers athletically for some of its students. Thank you. Thank you. Appreciate your being here tonight. We'll now welcome public testimony from members of the public. Is there anyone here who wishes to testify in favor of the application? Seeing none and understanding there's no one on Zoom, Ann Milkulka is here and wishes to testify in opposition. Oh, well, please come forward. We appreciate your staying at this late hour and participating in the hearing. Please introduce yourself.
My name is Ann Mikulka. I live in the Bryant neighborhood. I'm not going to take very much time. I am mainly here because I came here this evening because I wanted to try and save those 2 trees, but I don't think it's possible now that I see the track goes right past them. But I do want to say that I went there right before this meeting and there was no ribbon around the tree, and it seems like there should be one. And also, I heard just yesterday from a letter that I received from a resident that the sign was down or not there for several days. So I don't know if that's true, but I just feel like that's an ongoing issue that the city or someone needs to just kind of keep an eye on that, because it causes a lot of problems. There's a communication breakdown between the city and residents because of these problems. So because there was no ribbon and the sign was maybe down, and because at our neighborhood association meeting back in November 2021, we were told that no trees were going to cut down for these 3 reasons, I'm afraid that many people are not aware that these trees are going to get cut down. And they're right up against a fence, and there are homes on the other side of it, and a street. I disagree with the staff report in that I believe both trees are significant. They are due to size. They're very big trees. They have large trunks and they're high. They can be seen from various angles in the field and also from the street on the other side. And I also disagree in that I believe that they definitely are a visual screen. I was just there and I was surprised at how wide the 2 trunks are. They're right next to each other. And they serve as a screen for the residents who live in the house behind the fence. And it's also, not only is the trunk blocking the view, but also there are branches that are, not many, but there are branches lower down that do cover sort of the top part of the fence, or the part right above it. The trees also serve as a screen for noise as well as for light pollution, but it looks like that base is covered. Let's see, at the Bryant Neighborhood Association meeting in November of 2021, many residents expressed these concerns related to privacy and noise and light pollution. So I feel like these trees being cut down is something that needs to be not ignored. I think you all maybe should put a little thought into it before just approving this. So that is my main point. And also, I just wanted to ask that the people involved in this project please minimize the amount of plastic turf that is going to be used, and minimize the area that it's going to cover for the sake of the environment. And please minimize the amount of noise pollution that's going to come out of those speakers and the light pollution as well.
Thank you for your thoughtful comments. Are there any questions? We really appreciate your staying and making those remarks. That's very helpful. Sure. Thank you. Also, Mr. Donald Dell is here this evening, who I understand is neither for nor against, but wishes to share some comments. So thank you very much for staying. and for speaking tonight.
Well, my pleasure. First off, I'd like to start with asking, I've just got basically some questions. The site plan I received has an additional piece of work that's going to be done on it that runs up along the tennis courts, apparently, that isn't shown here. Okay, that one. Also, where it says existing cypress trees, those are not cypress. It's that, this box right here. They are cedar trees.
I see.
I don't know if that makes a difference or not, but most of them are 2 to 3 feet at the base, so they're old cedar trees. I own the piece of property that's adjacent right here and live there, right off the corner, so that area is my big concern. Right now, it's basically blackberry bushes and Devil's War Club. Had rabbits in it all year, and it doesn't indicate what's going to be done. There's a drainage ditch there that is on the school property that runs all along the tennis court. There's a difference of about 4 foot in elevation. Along that that whole side of the property, of the school property, there's a road that isn't shown on your drawing. And it's a driveway that serves all of those residences down that back property line. I'm happy to hear about the lighting because it's on all the time and it shines in my kitchen window, so I'm glad it's going to be changed. But I would like to know what's going to happen where the elevation is so much different, how they're going to finish that wall. If they're going to put a fence along through there, if they're going to begin maintaining where the old growth cedar trees are, because nobody's ever gone in there and cleaned them out. It's just all overgrown. There's trash and all kinds of, no maintenance been done. One of the other big issues is the parking. Right now, when school gets out, it's like a flood of kids going across that property line because the parents are all parking on deer brush. It's the Stooges demolition derby at 4 o'clock in the afternoon and 8 o'clock in the morning. Illegal U-turns, cars parked all up and down the street. When the soccer games are going and there's over 1,000 people out there on that field, it's just nuts trying to get around in the parking because there's no parking on Jean Road in front of the school. The parking lot's not big enough to handle all of the people participating in the events at the parking or at the school area. So the parking in and on deer brush, because they come on to deer brush on the back side of the school and on my side of the school. And it's like I say, kids are running across through our yards and all kinds of stuff. So something to be able to either make it neighborhood parking like they've done in other areas in other towns or even here. Just something to mitigate some of that traffic out of the neighborhood that is a result of the school. I get people not wanting to stop and go around the circle to pick their kid up because it takes a while. But what's happening now is not good, and it's going to get worse as this area gets more use. The other thing I would like to bring up is with this cell tower, there's considerable radiation coming off of that, and I'd like to know what the acceptable levels of radiation for this athletic field would be, and if there's monitoring being done for that radiation. So that is my other concern. The cell tower went in, I think, a year or so ago, year and a half ago. Many of my neighbors, as well as myself, were losing sensors. They're melting. Our outdoor lights are dying. Our remote controls for our televisions are dying. Our telephones will come on, get hot, and just drain. The only thing that could be doing that is that cell tower. So I'm concerned with the athletic events going on this field. How are these children going to be affected by this radiation that's coming off of these towers, if in fact there is radiation, and I'm wondering if anybody's monitoring that. So, and if so, how to get that information. That's about all I've got. I'm glad to see it being done. It's just, it's a high-used area. There's a lot of noise. That's the biggest thing is the soccer games start at 7 in the morning and they go till 9 o'clock at night, Saturday and Sunday. There's thousands of people coming and going. Most of the time, we aren't bothered in my area. It's fine. But I would like to know what's going to happen in that trashy area all along that ditch and up to there's a drainage ditch there, and when they did all the remodeling of the school, they blocked the drainage ditch, so now it just sits full of water until it evaporates. So, and that's on the school property. So something needs to be done. I mean, it's not clear what's happening in this area from the plan and the details. So I just want to put a red flag on there that needs to be cleaned up, and that's all I have to say. So, thank you.
Well, thank you. Are there any questions for this witness? Jeff?
Where's the drainage backup?
This drainage ditch starts about where the cedar trees start, and it runs up to Jean Road.
So it's between the tennis courts for...
Correct. And where it runs into Jean Road, when they remodeled, they put like one of the rock sumps in, you know, the overflow catch basin type of thing.
Yeah.
But they blocked off the drainage ditch and it doesn't drain anymore.
Well, then the catch basin doesn't get plugged.
That's right. So it's just a gross area. It's just covered with blackberries. Something needs to be done to clean it up. And I mean, the kids come off the field and they use that cedar tree area as their restroom because there's no restrooms in the field. They don't realize that our dining room windows are sitting there looking out at these cedar trees, and we're watching them do all of this and they don't even know what's going on. So that's life. But, and I'm okay with that, you know, it's just, this is what's been going on. I've had this property for 25 years and most of the time there's no problems. One time the light pole fell over and broke two of my big tall fir trees and would have crushed my house if they weren't there. I'm glad to see that's going away. I'm glad to see the light pollution's going to be mitigated a bit. You know, the noise and stuff you can't get away from, but I am concerned about the radiation coming off the cell tower, and I'd like to see that edge of the property cleaned up. So that's all I have to say.
Well, the school district representatives are here and have heard your questions and comments. I'm sure they may have some response to some of them, and we appreciate your sharing your experiences and your constructive perspective on the site. So thank you very much.
Yeah, my daughter says I should open up a beer garden. Anyway, thank you.
Thank you very much. Are there any other members of the public who wish to testify on this application, either in person or by Zoom? Hearing none, we would welcome rebuttal from the school district representatives on behalf of the applicant.
While they're doing that, let me just remind Mr. Waddell and the commission that the scope, of course, of tonight's concern is to review the application, the proposed modifications to the project, or to the property, and whether or not those meet the criteria. There may be ongoing and existing issues, and that should be brought up with the property owner, which would be a school district. If there are modifications that, you know, by this application that affect items, that's certainly within your purview, but
well, my question would be, it looks like to me they are making modifications in an area between the tennis courts and the property line.
Yeah, okay. I'm just saying not all the issues that Mr. Waddell raised, I think, are limited to the modification. And so I'm just saying there's another avenue for items that are not addressed by this commission.
All right.
Welcome back, and we'd appreciate any rebuttal remarks you might have.
Thank you. I think we'll just touch on a couple of things that we heard. Just want to make sure that folks understand we are not proposing speakers as part of this application. Amplified sound is not included as something that will be built with the project. Removal of trees. We did look really hard at the removal of trees, and we did our best to save as many as we could. The configuration of the track did just that. Upon bringing our arborist on board to look at the configuration of the track, we looked at opportunities as to how we could pave in different ways around the trees to hopefully retain them, finding out that it was quite impossible to do that. So we took the approach that we did with our final application here with mitigation trees and the final location of the track. Stormwater was brought up. We are mitigating stormwater according to code. I am unaware of the issue in the corner, which will be reviewed as a fellow property owner. I'll be reaching out to the gentleman that just spoke related to that issue. As far as parking goes, we do have, with the development of the middle school, we provided some overflow parking for large events. We wouldn't anticipate that would necessarily be used for this project, but it is available in the bus loop, so that does provide some additional parking opportunities. We've designed that parking lot to try to bring people in and give them an easy way out, so it is quite user-friendly. We have found that it has been successful and is being used in other locations for ongoing development in our district. We have experienced a lot more traffic kind of post-COVID with less ridership of our buses, so believe we still have quite a few kids that are being brought in by vehicles. One kid per vehicle, it seems, and they're all large SUVs. We continue to outreach to our parents and students about safe routes to school, walking, biking, different ways to get to school. Transit is an opportunity as well. Of course, riding the buses when they're available also helps. With this ongoing outreach and communication, we hope we can reduce some of the impacts to the neighborhood to the south. It is a concern that we've heard in the past, and we continue to try to mitigate it.
Yeah, again, Jason Gillies, I'm with the representative Lake Oswego School District and Cameron McCarthy, landscape architect. One other thing that was mentioned was just reducing the synthetic turf. We did, after the neighborhood meeting, we've reduced about 25% of the synthetic turf that was proposed based on that meeting and some other components, just to try to reduce the scale of the project. And that, what Tony had mentioned, kind of also spun into evaluating the trees a little closer with an arborist input, which is why we slightly shifted the track to protect the large group of them, and we did have one tree. We felt it was better, the group thought it was better to have one tree being removed for the sake of protecting the rest of them and keeping the health better on the rest of them. And we're proposing another 5 Oregon white oaks in that same area too, to kind of help rebuild that stand to the extent possible. And then the grading thing, I know Tony had talked about it, but the current field sheets towards the east, and there is a ditch along much of that property which will be reduced. We're picking up most of that water with this new field drainage, and the improvements that are being proposed between the tennis court and the property line are actually, that's where our storm pipe is going. So that area will be regraded to the extent possible, and any standing water issues that are there, we will definitely fix those at that time.
Commissioners, Jeff, did you have a question? Other commissioners, do you have a question of the school district and the rebuttal period? I just wondered, do you know, to your knowledge, to the extent any were required, were there ribbons on these trees that are being removed, and was there a sign up that you're aware of?
Yeah, so there was a sign, there were ribbons. Oftentimes the signs fall down, they get removed, we have to replace them. We usually take a picture. We have pictures of our sign also. It's happened on many of our projects. I think around the city, it's pretty common. We try to go out and check several times as we go through this period of proposal leading up to our hearing to make sure that things are there.
And there were ribbons on the trees as well?
Last time I went there, and my colleague here probably can attest to that as well.
Originally, I know they were, when we first put the sign up, there was a ribbon on the tree, but I have not looked at it since we originally posted the site.
Sometimes we mark them with paint as well, but that's been brought up as presumptive. So we try not to do that because it's paint on a tree. So we can avoid it.
Well, thank you, and thank you for that excellent presentation. We appreciate it.
Thank you.
Prior to closing the public hearing, any person may request an opportunity to present additional evidence that a request is made. The public hearing will be continued to a date certain, not less than 7 days later, or the record will remain open for at least 7 days to allow additional written evidence or testimony to be submitted. Is there a request to present additional evidence? Hearing none, does the applicant wish to submit a final written argument? No. You may proceed to deliberation, Mr. Chair.
Thank you. Commissioners, are there any questions of staff before we go into deliberation?
I do have a few, hopefully quick questions for you. Thank you for your presentation. I thought that was very well done, but I do have a few quick questions. One thing you mentioned, and I asked because not to touch on other projects too much, but I'd asked this about other projects about the lighting, and you had referenced a city code that said the lighting would be off by 10 p.m. So it might be inapplicable to these other projects because they were the Rasique Skate Park, et cetera. But I'd asked a similar question there. Is there a city code you can direct me to that says all or certain city facilities that have similar lighting must extinguish that lighting by 10 p.m.?
Yes. So pursuant to LOC 5006-004-3B, and then I'll see if Ms. Numanalu has the exact subsection that the automatic shut-off is.
Are you talking about this? The curfew?
No, there's not. Oh. 1 second.
Sure, I can also research it. It was more, I was asking you mainly just because you mentioned it, and it is something that comes up with some of our projects related to lighting and the impact on the neighborhoods. But it is not consequential to my vote on this project, so I don't want to waste your or anyone else's time on it. The comments here, this is evidence exhibit G204 Gibbs comment. And I apologize if you did address this in your report. I didn't think you did, but the two questions are, was a traffic study required? If not, why not? And then also his argument about because the district is adding a concession stand, which is not generally useful during school hours, that this should have been reviewed as a major development instead of a conditional use permit, separate from the school itself. Did you have any comment on that?
I do. So my understanding of the comment referring to a traffic impact study was referencing a past application for the school building, LU 180057. That's not a part of this application. Staff will note that there was a traffic impact study for that application, but that was the 2018 application, not this current application.
And this application did not trigger a traffic study requirement?
Exactly. There are specific standards that would trigger a traffic study. This application does not. So this application does not trigger any traffic study. There are no changes to access, parking. It's not believed to be a change to the use of the site since they are already used as existing athletic facilities.
Okay.
So it does not trigger a traffic study. And then in reference to the major development, so actually this application was reviewed as a major development. So a conditional use permit modification is a major development. It is a part of the school. This change was considered a major modification, a major development. It's part of an existing major public facility. So it was reviewed as a major development already.
Thank you very much.
And I did find the code section regarding the extinguishing of the lights, and it does require that all prescriptive or performance-based exterior lighting, which I think the applicant did the
Performance
Yeah.
for field lighting.
Shall be controlled by automatic devices or systems that initiate operation at dusk and either extinguish lighting at the curfew times, and there's a table that gives it the curfew times, or reduce lighting density at the curfew time to not more than 50% of the requirements set forth in the allowed lighting power density. In this particular zone, in the PF zone for a non-park use, the curfew time is 10 p.m., between the hours of 10 p.m. and 5 a.m.
Thank you. That is all.
Thank you for those questions. Bruce, did you have any remarks or questions? I just wanted to follow up regarding the ribbons and signage relating to the tree. Is there a requirement that there be yellow ribbons or signage relating to a type 2 tree removal? And we've heard testimony that some of the ribbons and signage was down, and that often happens. Does that in any way impact our jurisdictional basis to go forward or our schedule for acting on this application if there were no ribbons and signs around the trees at a certain point during the pendency of the application?
Well, this can be an ongoing problem with some applications where we've had people who have repeatedly put up their signs or marked their trees, and dissatisfied people or or vandals or whatever you want to call them have removed them, or sometimes, it may be just innocent. Who knows why people are doing it. In this case, the applicant is required to mark the trees with the yellow ribbon. The sign that they put up for a land use is different than a type 2 application in that it has a notice of public hearing, and it will state the date of the hearing. It will include that there is tree removal, but there isn't a yellow sign like you would see for a type 2 application. So that's the sign that should be posted at this site. That is supposed to stay up through the date of the public hearing at least, I believe. But the trees are supposed to remain marked until a final decision on the application is made. So if the ribbon has been removed, it should be reinstalled around the trees. We also mail a public notice to all properties within 300 feet of the site, plus the neighborhood association, and that includes a description of the proposal and an actual site plan showing the proposed tree removal. So all of the properties within 300 feet received a mailed notice, which is a notice that a typical type 2 would not receive. So in this case, I don't think that, I would let Evan, I guess, talk about whether anybody would be prejudiced by the fact that the sign fell down or wasn't up for some period of time, or the tree markings were not there the entire time. But unfortunately, this can be an ongoing project, especially on these large sites where a lot of the public has access to it.
I can certainly understand that. I just don't know how that impacts our deliberations, if at all.
The commission has previously wrestled with this problem. It's not unique, and made a finding, as I recall, that said that the applicant has to exercise sort of a good faith effort to try to keep the sign up. I remember there was a particular application where it was an individual homeowner kept finding the sign down, in her yard, and she kept putting it back up, and it kept going down. So the testimony in that case was that she made a good faith, reasonable effort to keep the notice up, and it goes up for a period of time. So while it might be down for a period of time, it might go back up. So that in addition to the individualized notice within this particular area on it, what the commission said was that's what was obligated, that a applicant was obligated to make the good faith efforts to keep the sign up and to keep the yellow ribbon on. You just can't expect that to happen, 24/7, but that they should kind of put the sign back up when they can. So you had the testimony that the signs, was up, and that their ribbon was on the tree, and it was up kind of recently and sort of thing. So, but if it's not up right now, that does not destroy your jurisdiction. Okay.
Thank you. Are there any other questions or comments to staff before going into deliberations? Commissioners, do you have any thoughts on this before entertaining a motion? Is there a motion, or Jeff, did you have a comment or the question?
I would move that we approve LU 22-0022 as conditioned in the staff report.
Is there a second?
Second.
If there's no further discussion, let's call the roll on the vote, please.
Arthur,
Yes.
Shear,
Yes.
Poinsett,
Yes.
Lyons,
Yes.
Dews,
Yes.
5-0.
This is a tentative decision by the commission with written findings brought back on, am I reading this right, October the 3rd? 7 p.m.
Very good, thank you. Now we'll move forward on our agenda to schedule review and management update. And Director Namanaloo, I'll just mention to the commission that you had alerted me before the meeting that in connection with the Aquatic and Recreation Center, that staff is preparing a letter along the lines we discussed about the 90-foot gap in the pathway, and will present it to us for circulation in the next week or so, as I understand it.
Yeah, that's correct. I have a draft. I want the engineering department to review it because there is some reference to the TSP and whatnot. I want to make sure that that all checks out for them. But I will go ahead and give a draft to the chair and the co-chair for initial review, and then we'll share it with the rest of the group, and we can have a final discussion at the next meeting before we forward that to the city council.
Thank you for following up on that, and Jeff, I appreciate your mentioning it also.
I do have other updates, if that's okay.
Please.
Okay. I just wanted to remind you that if you are interested in serving on the Housing Production Strategy Task Force, the council, I think I sent around an email, is looking for one DRC member to serve on that task force, the final selection will be made by the council. So if you are interested, just send me an email. No experience is necessary. And then we do have an upcoming meeting on October 3rd. There are 2 items scheduled for that evening. I do not have anything scheduled beyond that, but I would expect we would probably have at least findings on the second meeting in October. But certainly if we have any other applications that get scheduled, I will keep you updated. But next meeting will be 7 p.m. on October 3rd.
Thank you very much. Is there any other business for tonight's meeting? If not, and if there are no objections, we'll adjourn. We're adjourned. Thank you.
Aren't you going to volunteer for that task force?
You're welcome to do it.